So before we begin, I'm Kirsten Friday. I'm one of the co-chairs of the Alaska Native Law section. And today we'll be hearing from Ben Spieth, who is a partner at Landy Bennett Blumstein. He'll be discussing ANCSA land bank protections and 105L lease agreements between the Department of the Interior and tribes or tribal organizations. He's a member of the real estate practice group with a background in corporate law and also practices in the areas of land use and zoning, ANCSA, and public land.
Well, thanks. Kirsten and I are old friends. We used to sit together in the same office. So it's nice to see you, Kirsten.
Good to see you.
And I'm here with River Stern, who's an associate here at Landy Bennett in our Anchorage office. So today, what we will do is a little bit of some, I think, which are fairly basic topics. We're not covering ground which I would really consider to be too exotic or complex, but it's good refresher for all of us. And River and I have put together slides in both topic areas, and I think that our approach is going to have it be that this will be pretty light, and we'll go through the materials. We welcome questions and suggest that you interrupt as we go and ask questions. There's plenty of rabbit holes to go down in this material, but we're going to focus on the basics. But again, please raise your hand or put it in the chat or just interrupt with questions. So let's go ahead, and River is going to start us off with ANCSA land bank protections.
Hi everybody, I'm River. So there are two sections of ANCSA that prohibit taxation of undeveloped ANCSA land, undeveloped and unleased ANCSA land. These are sections 1620D and 1636D. And so essentially, as long as land isn't developed or leased, this ANCSA land is exempt from adverse possession or other similar claims. So prescriptive easement, that's in section 1636D. They're also exempt from real property taxes by any governmental entity. That's also part of 1636D. And then judgments resulting from a claim based upon creditors' rights. So these include bankruptcy claims, insolvency, and other miscellaneous creditors' rights claims. So what is the purpose of these provisions? So the main purpose here is to prevent loss of Alaska Native lands through adverse possession, confiscatory taxation, or foreclosure of liens. Basically just preventing involuntary loss, unplanned, unforced development. The Alaska Supreme Court has explained that section 1620D's tax exemption was intended to prevent these things. There's a quote that is not actually the quote here up on the slide from the Supreme Court saying that section 1620D as part of ANCSA is most clearly a provision implementing the policy of gradual adjustment to the economic mainstream. Furthermore, the tax moratorium permits the natives to pursue a traditional subsistence lifestyle, at least temporarily, without the need to exploit hunting grounds in order to raise revenue for taxation. An exemption is also important because of the danger of foreclosure for non-payment and the possibility of rapid movement of land ownership from natives to non-natives. There's also this quote here, which is from the congressional record for the 1987 ANCSA amendments. It says, protecting land and interests therein conveyed to native corporations pursuant to ANCSA from involuntary loss due to taxation, bad debt, bankruptcy, and adverse possession is one of the most important objectives of the Alaska Native Claims Settlement Act amendments of 1987, which these are also referred to as the 1991 amendments. So that's sort of the picture in terms of what was being considered here behind the land bank provisions. Some other good quoted material here from the congressional record for ANCSA amendments. The committee intends that lands conveyed pursuant to the Alaska Native Claims Settlement Act are to remain in native ownership as a legacy to be passed from generation to generation. The Alaska Land Bank program establishes a process through which undeveloped and unimproved native land or any interest therein, much of which is critical wildlife habitat selected as traditional areas of high native subsistence use, can be protected from disorderly, unplanned development and from involuntary passing from native ownership. So again, this sort of impetus here was to make sure that as through the passage of ANCSA and these lands, the legal status of these lands was solidified, that there was not going to be this sort of forced development and sort of that these lands would be subject to any number of claims that sort of went against the purpose of the statute. So the first of the land bank protection provisions was in the original ANCSA legislation. So this was section 1620D. And so in adopting ANCSA initially, Congress stated that the settlement should occur without adding any categories of property or institutions that enjoyed special tax privileges. And this was clearly sort of, there was some desire to avoid the reservation system and the sort of corresponding special privileges, immunities, et cetera there. But at the same time, section 1620D provided for a 20-year exemption from state and local real property taxes for land conveyed under ANCSA. And that was from the date of the passage of ANCSA, that 20-year moratorium. This exemption terminated if ANCSA land was developed or leased to third parties, at which point the land would become subject to municipal taxes, local real property taxes, and local assessments. As time passed, at the urging of Alaska Native groups, Congress became increasingly concerned that the 20-year moratorium was insufficient and that ANCSA lands would need additional protection from taxation and creditors. So Congress established so first they extended section 1620D through portions of ANILCA. They extended the tax moratorium to 20 years from the actual land conveyance date rather than the date of ANCSA's passage. And this other provision in ANILCA established the Alaska Land Bank program in section 1636 of ANCSA. So under section 1636, private landowners, including Alaska Native corporations, could enter into what was known as land bank agreements with the Secretary of Interior. And under these agreements, properties placed into the land bank would be compatibly managed with adjacent federal lands. The Alaska Land Bank program further provided that if a Native corporation placed ANCSA land in the land bank, it would enjoy permanent immunity from, among other things, real property taxes and assessments. So by 1987, there was a realization that this program that required Native corporations to actually affirmatively enter into agreements was too cumbersome. There had only been 2 agreements that Native corporations had actually entered into with the Secretary of Interior. And so in the what's known as the 1991 amendments, there was a new provision, section 1636D, which was added to make the protections permanent unless ANCSA land was leased or developed. And it also created what is known as the automatic land bank, which removed the requirement there were actually formal agreements entered into, and all of these ANCSA lands just automatically got those exemptions from taxation, assessments, etc. So how does this really work in terms of the immunity? So it's really a broad-based blanket immunity for all ANCSA lands that aren't developed or leased. And so this means real property taxes generally, special assessments, other governmental charges on land. So for instance, in the late 90s, early 2000s, there's a Native corporation that entered into a land exchange with the state, in which Anxa Land ended up later when a borough incorporated. The undeveloped Anxa Land ended up within the borders or within the borough's boundaries. And at the request of some landowners in the borough decided to construct some utilities across a right of way that fronted this undeveloped Anxa Land. And further, as part of that, the borough imposed a special assessment on this land. And there was some back and forth. The corporation sort of asserted that it was immune from this special assessment. There was some sort of early litigation. The parties ultimately entered into an MOU in which the corporation actually agreed to make these special assessment payments and drop this lawsuit arguing that it was immune. But then years later, the corporation, wanted to take a second look at it. They stopped paying, and ultimately, the parties came to an understanding that those lands were immune from the assessment and the agreement that they had entered into, in which the native corporation would pay the assessment fees, was void as illegal and against public policy. So that's sort of the broad breakdown of how this works, the history behind it, and the purpose. So I will hand it off to Ben.
So again, the land bank protections are automatic, meaning that all original Anxa land is automatically exempt from taxation, exempt from adverse possession, and exempt from creditor claims. With respect to adverse possession, I mean, this is fairly obvious. No one can make a claim of adverse possession against Anxa land, even if all of the elements of adverse possession are met. They would have they would never achieve any element of legal right to the land. And so what's kind of interesting to me about this is that the only similar or analogous situation is that adverse possession also cannot run against the government. I think, as we all remember from our first year real property classes, adverse possession does not run against the sovereign. And I like the notion here, the sort of the parallel treatment here of Anxa, Alaska Native land, also being a sovereign. And so in that sense, this makes sense. You can't adversely possess against the sovereign. In this case, the sovereign being an ANC, which has been, ANCs have been repeatedly recognized as tribal organizations with sovereignty under federal law. So note that there's some language in the statute which says not only will it, are they not subject to adverse possession, but then the language continues, it says, or other similar claims based upon estoppel. So this could be like, a claim for a prescriptive easement, which is, an easement right based on meeting the elements of adverse possession. Or there's also this notion of boundary line by estoppel, where the parties agree to a boundary line adjustment based on a pattern of use. But frequently that's not adverse possession because it can be done with permission, which is which would blow up an otherwise valid adverse possession claim. But I think the broad point is the important one, is no matter what you do, no matter where you are, no matter what a person's belief is, they will never acquire an adverse interest based on usage or estoppel in Anxa land. So it doesn't matter how long you squat, it doesn't matter how long you trespass, it doesn't matter how many years you've been, using this trail or road, or how long you've been hunting here, you will not acquire adverse possessory rights against Anxa land. The last one is this exemption from creditors. This is very broad. it means a couple of, pretty obvious things. If an Alaska Native corporation goes bankrupt, its land is not eligible for disposition or collection. It also means that if someone sues an Alaska Native corporation and they are successful and they have a claim against the corporation, the ANCSA land assets of the corporation are not subject to being sold and disposed of to satisfy the claim. They are immune from any kind of collection or attachment in that context. The other thing is that an Alaska Native corporation cannot easily use its fundamental ANCSA lands as collateral in connection with loans. They simply can't be attached under federal law. There are mechanisms and alternatives where an Alaska Native corporation could make its ANCSA lands available for attachment for collateral for a loan, but they are presumptively not available under section 1636 D. And it's useful, I think, at this point to go back to the beginning, to the purpose of all of this, which is to create durable protections for the ANCSA settlement, such that the land claim settlement and the heritage of Alaska Natives and shareholders of the corporations cannot be, inadvertently dispossessed, or perhaps not even inadvertently. If the ANC is mismanaged and ends up in bankruptcy, the shareholders in the community, the land base of the shareholders in the community is not at risk. And it's a powerful and important protection, which I think is squarely within the intent of ANCSA, and consistent with the purpose of the settlement, and does great service to the Alaska Native corporations and their constituents. So let's move on. Those are the three exemptions: taxation, adverse possession, and exemption from creditors. There's some big, but this is where it starts to get interesting. Those protections continue for so long as the land is not developed, leased, or sold to a third party. And this, of course, is where the rabbit holes start. What does developed mean? What does leased mean? And then what does sold to a third party mean? That's fairly obvious. But if you want to spend more on this, I would really recommend just going to ANCSA and reading these definitions of what developed means and leased means. They are in section 36D, part 2, and developed. Here's the definition. This is straight out of the statute. Developed means a purposeful modification of land from its original estate that effectuates a condition of gainful and present use, which is, I think, sort of murky language, without further substantial modification. And then it goes on here and talks about different things. I would note here down at the bottom that exploration, for example, oil and gas exploration or other exploration, does not constitute development for the purposes of the land bank protections. In other words, you could go out and do an oil and gas lease and explore for oil without losing the Alaska Land Bank protections. And then the last sentence of this definition, I think, is also interesting. Any lands previously developed by third-party trespassers shall not be considered to have been developed. So think about that one for a second. If a third-party trespasser, maybe it's a non-native or a non-shareholder, goes out and they build a commercial lodge on ANC land, maybe it's based on a good faith belief that they own it or have right to it or not. But if they go out there and they do that and they enter into a for-profit business, is that lodge and land subject to taxation? You know, it has been developed, they are making money there. And there'd be sort of two thoughts to my mind. Number one is third-party trespassers acquire no rights in ANCSA land, as we talked about a moment ago. And then the other thing is that if this third-party trespasser has thrown up a for-profit business, that for-profit business is certainly a development within the meaning of the statute. But because it's been done not by the ANC intentionally, but by a trespassing third party, it would not, the property would not lose the protection of the land bank provisions. So that's developed. Let's move on to leased. Again, if it's developed or leased, you lose the land bank protections. Leased, this means subjected to a grant of primary possession, entered into for a gainful purpose with a determinable fee remaining in the hands of the grantor. And then the second portion of this definition relates back to this exploration concept earlier, just clarifying and highlighting that if an ANC enters into an exploration lease, say with an oil company, that land would not lose its land bank protections. There's some further down in the statute, it clarifies it a bit further. These items here, which are specified, are things which an ANC can do without losing land bank protections. Number one, of course, is subsistence improvements. So if an ANC allows for or causes subsistent improvements to be made to for the purposes of subsistence or other customary and traditional uses, that will not be deemed development. So, for example, a client asked me not too long ago, gee, can we go out here and build a road and a boat ramp on our ANCSA land for the purposes of aiding shareholders and community members in a boat launch so that they can more easily access the lake and the river for the purpose of subsistence? And the answer to that is, yeah, that development would not constitute developed under the statute. You can build a boat ramp, you can build structures to serve subsistence purposes. The next one, hunting, fishing, and guiding. The receipt of fees related to hunting and fishing and guiding isn't developed. So if an ANC enters into an agreement with a guiding outfit to permit for-profit hunting activities, and the ANC receives fees in connection with that, does that constitute developed such that you lose your land bank protections? And the answer is no. You can enter into agreements with third parties for hunting, fishing, and guiding without losing the protections. Logging was a big topic back in the 70s and 80s when these amendments, when the ANCSA was passed and the amendments were passed. This is sort of an interesting one. Land upon which timber resources are being harvested shall be considered only during the period of such harvest, and only to the extent such land is integrally related to the timber harvesting operation. And so it does become, ANCSA land being logged does become developed for a portion of time that the logging is ongoing. I will say I've never had to deal with this provision in real life, so I don't know exactly what it means, but so long as you're not logging, you're okay. Once the logging is over, you're okay. Exactly how this would be applied to an active or proposed logging operation, I just don't have experience with that. But I thought it was interesting. And then this last one, exchanges among native corporations. Again, I don't have experience with this, but also exempt from the definition of development. Let's go on to the next one. So in my experience, where I've dealt with Alaska land bank protections, typically where it arises is where an Alaska Native corporation wants to use or develop or their land in some fashion. So I'll give two different examples, and these are just simple to give an idea of how this works. Example number one, an Alaska Native corporation owns a large tract of land adjacent to the village. Let's say that this land is 1,000 acres. And this is based on a very recent example I dealt with. And the Alaska Native Corporation wants to build a housing facility for use by a third-party contractor who's coming into town to do work on housing and then also other construction and development projects in the village. So the ANC is going to build this thing, this housing facility. Then they are going to charge rent to these third-party contractors who come into the village for the use of the facility for housing. How do you proceed? So our advice in that instance was that you should subdivide this parcel out where the residential development is going to occur. Recall, this section of land is a 1,000-acre piece of ANCSA land. So the risk here is that the ANC builds the housing facility and rents it out. And the risk is that the entire 1,000 acres is now deemed developed for the purpose of the statute. And that means that for the entire 1,000 acres, you've now lost your land bank protections. So the thought would be subdivide out this very small portion, which is going to be used for this development, and thereby protecting the 999 acres, which are the remainder. Those 999 acres will continue to get the benefits of the land bank protections. The one thing to note here at this moment is that there's an Alaska statute under 40.15.010 that requires subdivision in the event a party sells a parcel. So if you sell a small parcel of land for development, you know, the land must be subdivided. The subdivision under ANCSA, the land is considered developed for the purposes of the loss of land bank protections upon recording of the subdivision plat. So just the practice tip here is that that means as soon as you record, the property is now, quote, developed. So if you are engaged in a development, it may be wise to delay recording for as long as reasonably possible to avoid losing the land bank protections. So I'll give an example in this area. An Alaska Native corporation in Southeast Alaska, which is engaged in a development around in support of cruise ship operations. So this land, which would be subject to this development, you know, will need to be subdivided, and those plats will need to be recorded. The notion here is, in the timeline of development, the recording should be, you know, delayed until, you know, number one, we're certain that this project is going to go forward, and it also should also be delayed until we're certain and ready for the development to proceed. Because if you subdivide and record, but it's not until 5 years later that you actually start clearing trees and pouring concrete, you've had 5 years where you're subject to taxation without any real beneficial use of the property. That's the the practical tip and the notion. So let's go back. Questions or comments on Alaska land bank protections? There's a lot of experience in the people with these provisions among the folks on the line here. Thoughts or comments or questions? Hearing none, let's keep going on to our next topic. Oh, I'm going to say one other thing about ANCSA real quick. Just quickly, this is again on the topic of losing Alaska land bank protections. To note, if you do 14C3 conveyances to the state or the municipality, well, you don't lose them when the 14C3 lands are conveyed to the state in trust, but you may lose them when they're transferred to a municipality. The next sort of side note is home site programs. Not many Native corporations have pursued home site programs. This is a program which allows ANCs to convey small parcels of land to shareholders and stakeholders in fee, ostensibly for residential housing. You can take part of your ANCSA land base, chop it up, and convey it to persons for residential housing. Note that if you do that, if you pursue a home site program, those parcels which are conveyed out to shareholders and community members lose their Alaska land bank protections. This is a program which can have its value, but there are situations or there are cases, particularly the ones I know of in South Central Alaska and Southeast Alaska, where village corporations pursued home site programs and conveyed small parcels of, between half an acre and 2 acres out to shareholders for home sites, and then those parcels were immediately turned around and sold to non-community members. The land bank protections were lost, and it resulted in a big fragmentation of the ANCSA land settlement in these village corporations. So just a side note. So we're going to completely change topics. And this is, again, the only similarity between ANCSA land bank protections and this new topic, which is the 105L leases, is I think that they are kind of similar in sort of being I wouldn't say Alaska Native Law 101, but they're common topics in Alaska Native Law. So just quickly, 105L leases are leases between tribal organizations which provide services which would otherwise be provided by the federal government. Leases between those entities, those tribal organizations, and the federal government to reimburse the tribal organization for their facility costs. The big picture here is that since the 1960s, there's been a drive in Alaska Native law toward self-determination. And part of this has been a shift from the government providing services, the BIA, the Department of the Interior, or some other subdivision of the Department of Interior, or say the Indian Health Service, a shift from those federal entities directly providing services to the federal government empowering tribal organizations to provide those services to their own members. That's the broad current of the shift in public policy. And in this spirit, there are a series of federal statutes were passed in the 70s and 80s. Among them, the Indian Self-Determination and Education Assistance Act of 1975, ISDA. And these 105L leases, which we're going to talk about, are creatures of ISDA. Again, sticking to the high 10,000-foot level here, you know, self-determination is great. It's a great concept. Let's get tribal organizations to provide services to our own members. It's about self-determination, autonomy, and sovereignty. But it's not without its challenges, namely that frequently in these service areas, there's a lack of infrastructure, whether it's buildings, utilities, etc. There's frequently a lack of qualified people, teachers, doctors, or nurses. And there's a lack of funding. You know, where do these tribal organizations get the resources to provide these services? And that lack of funding is both for the services themselves, but also for the infrastructure and facilities to provide these services. And so self-determination is terrific, but comes with its own set of problems. And just to note here, you know, funding is a huge challenge for a lot of reasons. The appropriations from Congress may fall short. It's worth noting that many areas of the United States, which are traditionally, you know, areas of interest for tribal organizations, have suffered from decades and decades and decades of underfunding, and are, you know, behind many other parts of the country. There's historically, Native communities have suffered between territorial disputes between state and federal agencies over who provides the services and at what levels. And then last, I think it's worth reminding all of ourselves that frequently there are disputes among tribal entities. And I think we all remember the CARES Act, a very recent CARES Act dispute, where tribes in the lower 48 asserted that Alaska Native corporations were not tribal organizations eligible for the receipt of CARES Act funding, which led to, of course, a massive dispute in the intervention of the U.S. Supreme Court. But these are all in the nature of these funding challenges for tribal organizations providing services. So, just more on this, the architecture of ISDA. You know, ISDA has been hugely important in driving the self-determination. And to get a little closer to the ground, Title I and Title II allow tribal organizations providing services to enter into self-determination contracts to take control of and provide federal services under federal programs. These are variously called 638 contracts or self-determination contracts. Just to pause quickly, self-determination contracts are different than self-governance compacts. Self-governance compacts are compacts where the tribal organization negotiates for to provide a broad array of services, for example, under the Indian Health Service. And we have a perfect example of this in our own backyard here in Anchorage, which is the Alaska Tribal Health Contract, under which the Federal Department of Health and Human Services and tribal entities entered into a compact under which ANTHC provides health programs for all Alaska Natives at the Alaska Native Medical Center. By contrast, you know, SCF, South Central Foundation, is a tribal organization which enters into a self-determination contracts. SCF providing health services in South Central Alaska. Okay. So again, back to our 105L leases. 105L leases are key instruments to drive funding in the self-determination model. 105L leases were first provided for in the 1988 amendments to ISDA. And what it does is it allows tribal organizations who are providing federal services to enter into agreements with the applicable federal agency under which the tribal organization is reimbursed for their facility cost. The facility, to think about this for a second, if there's a tribal organization which is providing services using a facility, that building, for example, it could be owned by the tribal organization. The tribal organization, let's say a healthcare provider, may lease it from a third-party owner, or they may have a trust interest in the facility of some kind. 105L lease agreements are available to the tribal organization, however it's owned. And then what happens is that the tribal organization will enter into a negotiation with the applicable federal agency for reimbursement of the costs around the facility. It's important to remember here, the name is a bit misleading. People often refer to them as 105L leases, but these aren't real property leases. At least they're not normal leases. These are cost reimbursement arrangements, is really what they are. So let's imagine that you are out there running you're running a medical clinic. And let's say this tribal organization is a tenant under a lease. And let's say under this lease, the tenant, healthcare provider, pays for everything. They pay rent, but this tribal organization is also obligated to pay for capital replacements to the building. For example, if your roof gets blown off in a windstorm, the tribal organization and healthcare provider has to replace it. Let's say you have to pay all operation and maintenance expenses. You've got to pay all your utilities. You also have to pay the cost of ordinary maintenance, whether that's janitorial or painting and maintaining the exterior, window replacements, replacing the light bulbs, paying for a property manager, plowing the parking lot, you name it. Those are all costs which are incurred by the healthcare provider in this context. And under a 105L lease, under this reimbursement agreement, all of those costs are eligible for reimbursement from the federal government. And the intent here being to reimburse the tribal organization, which is providing services, for 100% of their incurred utility costs. So if you think you may be eligible for a 105 lease, but you are not yet you don't presently have one, you know that you are going to need to be negotiating with the applicable agency. That could be BIA, it could be the Indian Health Service, it could be the Bureau of Indian Education. There you are going to want a detailed breakdown of the costs and expenses of operating this facility. I would anticipate that the tribal organization is going to need to prepare a pro forma operating statement showing all of these costs. And I put here, don't forget reserve replacement or allowance and depreciation. There are a lot of things you don't need to forget, but that's among them. But it's you would need a detailed statement showing remember, you need to demonstrate that all these costs are real. And the other thing is they will reimburse you for your rent, but it needs to be fair market rent, and you need to be prepared to establish that. This gets into some complex accounting errors. I think the only thing to note here is that if it's a tribal organization which is already being reimbursed for certain services in other areas, you need to be careful about getting a double reimbursement. The particulars of that are beyond the scope of what we're talking about here, but it's something to be aware of. So the last thing I want to talk about here is something which is sort of just emerging on the scene, but I think has the ability to be extraordinarily powerful for ISDA tribal organizations who are providing services which would otherwise be provided by the federal government. And the idea is this, which is that these 105L leases, these cost reimbursement agreements, can be used as collateral for loans. And you can take your cost reimbursement agreement with, for example, the Indian Health Service. You can take that agreement, you walk down the street, and you go to the bank and you say, I have this cost reimbursement agreement. I want to pledge this agreement, my right to receive these payments. I'm going to pledge this for a loan. The bank gives you the loan with the 105L lease as collateral, and then you can use those loan proceeds for other purposes. So the idea is that, let's say you're a healthcare provider and you are running a medical facility somewhere, and you have a 105L lease agreement under which you are reimbursed $1 million a year. You could pledge that revenue stream to get, say, a $5 million loan from a private lender, say KeyBank, and you could take that $5 million and you could go and you could use it for another purpose, say maybe to build an office building or build another medical facility or whatever. I mean, it's not completely open-ended, but you get the point. The proceeds of the loan do not necessarily need to be used for the in connection with the applicable facility that the 105 lease is related to. So I'm a bit cautious on this because I've heard quite a bit of discussion about this as a new means of providing loan financing into the Native community and the tribal organizations who are providing government services. It's a powerful, it's a powerful new tool to enable credit in the in this aspect of the Native community. I've never done one of these loans, but I will say that in concept, it makes perfect sense to me. I don't see why it wouldn't work. Alaska Native corporations pledge, basically what you'd be doing with a loan like this is you would be, pledging your payment rights under statute as collateral. We have a right to receive this money under section 105L of ISDA, and we are pledging that to you, the bank, in exchange for a loan. Not uncommon, and ANCs are already doing this. For example, village corporations using their 7J funding as collateral for loans. And so it's an idea. It seems to make sense to me, but I've never done a loan like this. But there are lenders out there who are chatting up this concept and appear ready to make loans on this basis with 105L lease reimbursement agreements as collateral. So with that, I will stop talking. Thoughts or questions?
Yeah, hey Ben. Sorry,
Go ahead.
can you hear me?
Ben.
Hey, thanks so much for the awesome presentation. This is Segulik Liz Hensler here calling in from Kotzebue. And one thing that I was thinking about when you were talking was just like the human story behind making this 105L lease program that's been in statute for so long come to life. And that was like the leadership of Maniluk Association around 2014, 15, 16. They sued the federal government, and it was Jeff Stromer with Hobbs Strauss who was really kind of the artist behind the litigation. And even community members like tribal leaders from Kivalina went and sat in the court hearing in the district court in DC. I was there too. And just really, I think showed a really strong showing that like historically the federal government underfunds provision of Indian Health Service by about 50%. And then of course the BIA services are underfunded. And so this was such a great, and is.
Oh, Liz, you cut out. Hey, Liz, it's Ben. Can you hear us? And can you were cut off, but I want to hear what this is. What you're saying is terrific. Can you get back on?
So Ben, until she can get back on, there was one question in the chat that if an agency leases land to a tribe that uses the land for a for-profit enterprise, are the land bank protections lost?
I think that yes, there's a risk that the Alaska Land Bank provisions are lost, particularly since it's being pursued for a for-profit purpose, which I think would fall within the definition of development, the definition of developed under 1636D. I mean, I hesitate to give legal advice over Zoom, but because everything is so fact dependent. But that's an example of a situation which I think would require some close analysis. Yeah.
Liz, are you able to unmute?
Yeah. Hey, Liz Hensley, are you back? Can you hear us?
You know what? I think my partner started our talk and then stole my connection over Bluetooth.
Oh,
So
well,
I hear you now.
Can you continue? I want you to finish. I think what you were saying was really interesting. And can you finish your thought? Where you cut off was that that folks from Maniluk and Kotzebue were back in the courtroom in Washington, D.C., and you were talking about the pattern of underfunding. Can you pick that up?
Oh, sure. Yeah, happy to. Oh, I just wanted to my main point was the federal government had chronically underfunded IHS and BIA services, really to like the peril of Native people and their health status. And then and this 105L lease provision of ISDA wasn't being, it was just like people didn't even realize it was there, kind of. So then Maniluk sued, and Jeff Stromer's, he was just an artist on figuring out how to get this thing through, and in his litigating on behalf of Maniluk. Kivalina tribal leadership went to the court. It really just made a strong showing. And so I think my main point was kind of never underestimate the ability to really improve people's lives through, taking a stand on some of these things. And it was really cool to see something like this 105L lease thing being completely non-existent except for in the written word in the statutes, to now being this full-on program across the whole nation that the BIA and IHS are actually trying to fund. So it's been really cool to see that over the last 10 plus years. And it's really made a huge difference. And here, little communities really making national policy and improving people's lives is pretty cool to see. So that's what I was trying to share before my connection got stolen by the truck that's out in front of my house.
Liz, can I ask you a question?
Yeah.
So for those who don't know, Liz Hensley's like extremely experienced in healthcare, having worked for Manilic for many, many years. But here's my question, Liz. Is it your sense that the 105L leases are underused? In other words, that there are many tribal organizations who are providing services who could get the benefit of these agreements, but they just don't have them in place?
Yeah, and thanks for your kind words. I feel like I'm always, learning along the way here. Yeah, they are. I mean, we went from like a decade ago, like nobody even realizing this was on the books as an opportunity, to now it being more known, and kind of like people are just still needing to like spread the gospel, hear the gospel. And then of course the government has to continue figuring out how to pay for these things, because it is like an obligation, but they haven't necessarily set aside the funding all the time to pay for it. So I think there's a lot that has to go into that. But yeah, totally underutilized across the nation, and increasingly used. And I think your presentation helps with that, right? It's good to learn about it.
Let me make a small point. The other thing that may be worth noting is that if a tribal organization is only using a portion of a facility, let's say you have a small office somewhere, and let's say you have a small office building somewhere, and one part of the building is used to provide services. You can be you could have a 105L reimbursement agreement which relates to that portion only. So if it's 25% of your building is used for the provision of these services, you can get a reimbursement of 25% of the cost. So just because there's a portion of the building which is not eligible, you can still think about the remainder. So Liz, that's hugely helpful. Thank you. I actually did not know about that lawsuit. That's really interesting. I'll look that up.
Yeah, no problem. There's like some Ambler cases and Cavallina cases. Yep.
Cool. What else? Thoughts or comments? I mean, again, I would say the people on this call are, have a lot of experience with these kinds of arrangements, I am sure. Thoughts or comments? And if not, we here at Landy Bennett Blumstein, River and I are very, very grateful that you guys have taken the time to join us to talk about this stuff. We could go on for hours and hours and days and days. These are really interesting topics, and invite folks to be in touch with us. And yeah, as Liz says, just keeping the dialogue going and keep pushing oxygen into these topics so that people are alive to them is really important. So thank you for your time.
Well, thanks to you and River for presenting.
Okay, thanks all. With that, we will sign off. Thanks so much.
Thanks, folks.
Go to